Counsel, whenever you're ready.
Thank you. Good morning, Your Honors, and may it please the court. We asked this court to affirm the decisions below, and the decisions below specifically are that actual notice was complied with in conformance with State Government 12-106B1, and that actual compliance occurred with regard to the 3-year filing deadline. Taking the state's arguments in reverse order, regarding the notice provision and regarding notice compliance, Judge Rubin found, both as a matter of law and as a matter of fact, that proper notice was complied with. The record extract at page 376 has Judge Rubin's decision articulated there, and contrary to what the state just represented, Judge Rubin did not just incorporate earlier rulings by the court, by herself, in making that determination. She states on the record, I'm exercising my own discretion and finding that proper notice was complied with. After the plaintiff's case in chief, when the plaintiff put on testimony that 2 notices were sent in October of 2013 within 30 days after the injury, where the plaintiff offered evidence by way of Exhibit 30, it's at the record extract at page 550. That was a correspondence sent to the state treasurer 15 months after the injury that references the earlier notices. And after Mr. Younger testified that in the weeks and months subsequent to the attack, all of his personal property was confiscated from him and never given back to him, which included the copies of his notices. And so after that evidence was offered at trial, and without any questions on cross-examination, without any rebuttal evidence by the state of Maryland, and without any request for a jury instruction of any kind, Judge Rubin at the close of the plaintiff's case in chief said, I have not changed my mind. In other words, she incorporated her own ruling from just before the trial because the only evidence that was offered supported and bolstered her ruling. And what closes the door on the state's notice defense, Your Honors, is the state's stipulation to a spoliation instruction. And that's found at the Appellee's appendix at page 26. Maryland Rule 2-433 explains what spoliation is, and it's the destruction or failure to preserve evidence.
Yeah, but there are a lot of cases that say that evidence of spoliation doesn't generate affirmative proof of some fact. It's just a reason to disbelieve something. So I'm not sure how spoliation gets you anywhere.
Well, we're not arguing that it's an affirmative proof of fact. What we are arguing is that in addition to the actual proof and testimony that Mr. Younger offered in support of his actual compliance, the fact that the state not only didn't just defend its notice position by saying Mr. Younger can't produce the actual document, but then went the additional step along with several tranches of documents that should have been there but weren't, and stipulated to the fact that we should have been able to find this. We believe it to have been at the treasurer's office, but it's no longer there. Mr. Younger, we argue, Your Honors, that all of these things together form a clear evidentiary basis for Judge Rubin to have made the finding that she found below, that actual and proper notice was complied with. Worst case scenario, we can certainly say that Mr. Younger substantially complied with the notice provision. And the reason why is very simple. The purpose of notice is patent. It's well established in the case law. It's to give the state an early opportunity to investigate the facts, preserve evidence, and hopefully resolve the claim with some expedience. Here, we know that the state was on notice by Mr. Younger's testimony, albeit without the physical piece of paper. But in addition to that, we also know from the state's actions following this attack that the state was well aware of the facts of the attack, the facts of the incident, all of the players. The state proceeded with criminal indictments of the various assailants within 1 year of the injury.
Were these guys criminally convicted?
They were, Your Honor, yes.
I'm sort of wondering how the jury didn't find malice that would disable a Tort Claims Act.
Oh, they only found what they were asked to find, Your Honor. And there was never a request by the state of Maryland for a finding of gross negligence or malice. It went to the jury on a single question of negligence. And so at worst, we have substantial compliance where the purpose of the statute is fulfilled. But we say that Your Honors don't have to reach substantial compliance because we actually complied with notice. And there's nothing in the record to overcome the evidentiary basis or to obviate the evidentiary basis that Judge Rubin had below in reaching that conclusion.
Now, counsel, even if you are correct on your notice argument, you still have to get around limitations, right? There's no substantial compliance standard for limitations, is there?
Well, thank you, Judge Zarnock. I'm getting to that right now. As far as the 3-year filing, we also say that we actually complied with the filing requirement that's articulated in State Government 12106B3. The plain language is very clear. It says that in order to institute an action under the Maryland Tort Claims Act, you have to file the action within 3 years after the cause of action arises. That's what the statute says. That's what the plain language says. That's what we did. It's undisputed that we filed a complaint on September 28th, 2016 within 3 years, albeit not in state court, but it was filed within 3 years after the cause of action arose. There's no expansion of the waiver of immunity by finding in our favor, because what the waiver of immunity tells us, the 12104 waiver of immunity in the Tort Claims Act, it just tells us that the state waives its immunity for certain enumerated non-malicious torts in state court up to a statutory cap. That's what the waiver is. The procedural requirements to bring a claim against the waiver are separate from the waiver itself. And so the intended result of the Maryland Tort Claims Act is to have a judgment in state court within the limits of the statutory cap. And that's exactly what happened here. We're not arguing that the condition precedent, the 3-year filing condition precedent, was waived. We're not arguing that Rule 2101 saves the condition precedent aspect of that requirement. We're saying that we actually complied. We filed the action within 3 years. It's important to note that, again, as I alluded to, the waiver of immunity and the conditions precedent to bringing an action are separate. They are related but separate. They come from 2 different directions. On the one hand, in 12104, the state waives its sovereign immunity under those circumstances. On the other hand, a claimant who has a potential claim that fits within the 12104 waiver has certain procedural requirements that he or she must satisfy in order to bring the claim, not in order to have the waiver effectuated. In other words, the waiver is in effect by virtue of 12104. And that's true whether a claimant satisfies the procedural requirements or not. And a failure to satisfy the procedural requirements is simply that. It's a procedural default for failing to follow a condition precedent. It's not that the state hasn't waived its immunity. And so, excuse me, when you separate the two sections like that, and you recognize that these conditions precedent are conditions to bringing an action against that waiver and not conditions to effectuate the waiver itself, it's important to look at the guidance that existed in September of 2016 when this complaint was filed. The guidance that existed at that time was the plain language of 12106B3. You have to file the action within 3 years after the cause of action arises.
Why don't we read 12106 in conjunction with other sections in the same subtitle, like 12104, and reach the conclusion, as they did in the Sheriff Eldon case, that you need to file within 3 years in a court where the state has waived its immunity.
Your Honor, there are 2 questions in what you asked. And so as to the first one, we do read it as a whole. And that's why the waiver and the conditions precedent kind of coexist, if you will. We're not suggesting that somehow you take 12106B3 and read it in a vacuum. We acknowledge that the waiver of immunity is only valid in a state court. We also offer that the waiver of immunity and the conditions precedent to bringing an action are separate and distinct from one another, in the sense that—
Suppose for some reason, let's say Mr. Younger got out of jail and he moved to Hawaii, and he decided that he wanted to bring a Maryland Tort Claims Act case against the state in a state court in Hawaii. Would that, and suppose he brought it on, 2 years and 363 days after he was injured, would that be sufficient?
Under our argument, yes, it would, because again, only as to the condition precedent aspect, not as to the waiver of immunity. That's very clear that the waiver is effective only in state court up to the limits of the cap. That's not what we're not arguing, that it expands beyond that. We're saying that as far as the conditions precedent go, as far as the procedural requirements go, there is no requirement in the statute that says those conditions must be satisfied in the court of the state. And the second part of your question, Judge Arthur, had to do with why doesn't Sheriff Felden control, basically? Why is this not the same outcome? Well, Sheriff Felden doesn't control for many reasons. Number one, the issue before Sheriff Felden was a different statute, and it was a different issue. The Contract Act, or the ability, the state's limited waiver of immunity for breach of contract actions, which is found in the very next subtitle behind the Maryland Tort Claims Act, is a much different statute than the Maryland Tort Claims Act. Number one, the statute itself shortens the general statute of limitations for breach of contract actions from 3 years to 1 year. It's a much more
really it expands it for actions against the state, because before the act was passed, you couldn't bring one, right?
Okay, fair enough. But when you're comparing the Contract Act to the Maryland Tort Claims Act, the Contract Act is a much more restrictive statute by way of a conditional waiver of immunity. And in addition to that, Your Honor, the Contract Act is devoid of any mandate, broad construction mandate, like we have in the Maryland Tort Claims Act in 12102, that says you interpret the statute and construe it broadly. There's no such language in the Contract Act, which means that there's a strict application and a strict construction in favor of the state. The Sheriff Felden case examined that statute and answered the question of whether Rule 2101 saves a late filed Contract Act claim in federal court, because the original breach of contract claim was at least arguably late filed in federal court. It's not our issue, and it's not our statute. So back to the guidance that existed at the time that we filed, we have the plain language of 12106B3. We have Sheriff Felden, which comes close to these issues, but is very different. And also the Sheriff Felden opinion expressly limited its holding and says we don't offer any opinion about any other conditions precedent to suit in other types of statutory constructs.
But that's just good opinion writing. That doesn't prohibit us from taking the tools in the Sheriff Felden case and deciding whether they apply in this case, does it?
Fair enough. But when you start comparing the Contract Act to the differences in the Maryland Tort Claims Act and add them into the other guidance that existed, there's statutory support for both positions, Your Honor. And that's really what I'm getting at. That at the time that we filed, the plain language supports us. Sheriff Felden is distinguishable. And then we have the Higginbotham case, which deals with the right statute, but deals with an entirely different issue. And fascinatingly, the Higginbotham court looked to Sheriff Felden and cites it for support that the 12106B3 filing requirement is both a condition precedent and a statute of limitation. And in so doing, into that very plain language of you must file the action within 3 years after the cause arises, the court in Higginbotham actually enlarged the scope of the state's waiver of immunity for defamation actions, moving the general statute of limitations from 1 year to 3 years. And somehow it gleaned that legislative intent from this plain language of the action must be filed within 3 years. We're not suggesting that this court do any such thing in this case and enlarge or broaden the scope of the sovereign immunity waiver. All we're saying is that we should be entitled to the benefit of an application of the plain language of the law, coupled with the broad construction mandate in 12102. Also, and importantly, Your Honors, Sheriff Felden discussed at length the case of Irwin versus the Department of Veterans Affairs. And this is a Supreme Court case in 1990 that dealt with the Federal Tort Claims Act. The Federal Tort Claims Act, like the Maryland Tort Claims Act, has a notice of claim and a filing requirement. These are conditions precedent. The Supreme Court held in that case that there is a rebuttable presumption that applies to all of these Federal Tort Claims Act cases, that equitable tolling principles apply to save those actions. This was a big deal in the Sheriff Felden decision because Sheriff Felden looked at Irwin and said, we can't impute an awareness of Irwin onto the legislature because the Contract Act was enacted well prior to the Irwin decision and it was never amended after the Irwin decision. Had it been, maybe we could impute on the legislature this awareness that Irwin exists and therefore that there's this presumption that equitable tolling principles would apply. And equitable tolling would not only include Maryland Rule 2101, but of course it would also include.
But equitable tolling sounds like something that applies to limitations, not to the satisfaction of a condition precedent.
That's correct, Your Honor. And so, however, the Supreme Court in this case, in Irwin, applied it to a condition precedent. It applied it to both. And because Higginbotham tells us that 12106b3 is both a condition precedent and a statute of limitations, there's certainly there's an analogy, at least at a minimum, to be made, but I would argue that they're really the same thing, because the Supreme Court interpreted these filing requirements as true conditions precedent, and notwithstanding that, they said still equitable tolling can apply. What's important, and what the Sheriff Felden Court even said, is that we may have decided this case differently had we been able to impute Irwin onto the legislature. Well, Your Honors, in 1994, the legislature amended the Maryland Tort Claims Act's conditions precedent to read the way that they do today. And specifically, the 12106b3 filing requirement was amended in 1994. And the legislative intent, as it's stated in Higginbotham, was to make the Maryland Tort Claims Act's limitations consistent with the general 3-year statute of limitations. That's what the legislature told us it was doing. Of course, that amendment was 4 years after Irwin. And so I would offer to this court that even if the court doesn't find that we actually complied with the letter of the law, with the literal reading and what the literal requirements of the text mandate, surely there can be an imputation of awareness on the legislature of the Irwin decision, given that the legislature amended the Maryland Tort Claims Act's filing provision after the Irwin case was decided. And not only that, but we know that the legislature, we have some proof or indicia that the legislature was aware of this Irwin decision, because in 2015, the legislature codified the doctrine of substantial compliance as it pertains to notice, amending the statute and codifying a practice that Maryland courts were employing for 30 years before this, finding that, substantial compliance with the notice provisions was satisfactory to satisfy the condition precedent. And so there is support to impute this awareness onto the legislature. At the end of the day, Your Honor, and at worst, we ask that Irwin is imputed, because when you look at the purpose of the Maryland Tort Claims Act, when you look at the legislative intent of what 12106b3 is supposed to be, when you look at the guidance that existed or the lack of guidance that existed at the time we filed this complaint, and when you apply the broad construction mandate of 12102, at a minimum, there is substantial compliance with this condition precedent. Because at the end of the day, filing within 3 years, if the distinction is, if as to a condition precedent, the distinction is determined that you have to file it in state court, it kind of makes the 3-year filing requirement somewhat arbitrary. Because nowhere does it say you have to file within 3 years to effectuate the waiver. It says you have to file within 3 years to be able to bring an action against the waiver. And so we say that there is substantial compliance with that provision. That substantial compliance is well supported because of Irwin. And at a minimum, and maybe even alternatively to that, there could be, because of the Irwin decision, some type of relation back to the original federal complaint, or as is discussed in the briefs, that because of this dual nature of the condition precedent of the 12106b3 filing requirement as both a condition precedent and as a statute of limitations, our filing satisfied the condition precedent. Maryland Rule 2101 saves the statute of limitations aspect of that requirement. At the end of the day, Your Honors, you can send a signal to the General Assembly with this case that if you don't agree with this decision and don't agree with the literal interpretation of 12106b3, you can amend the statute. But that is a function of the legislative branch. And certainly Mr. Younger should not be prejudiced, because this is truly a matter of first impression when it comes to the interpretation and the application of 12106b3 and these other principles. Because we are both supported, because the state's position and our position are both supported by the statute, because we can both technically be correct, that ambiguity should lean in our favor. The tie should really go to the runner in this case, because we reached the intended outcome. We reached the outcome consistent with the purpose of the Maryland Tort Claims Act. and there's no expansion of the waiver. The waiver still is in state court up to the limits of the cap for these enumerated torts. If the Higginbotham case could read into 12106B3 that there's an enlargement of the state's waiver of sovereign immunity, there's certainly enough support here to find in our favor, and we ask that you affirm the decisions below. Thank you, Your Honors.
And thank you, counsel.
Before you sit down, before you stop, can I just ask you what's happening, or what happened in your federal Section 1983 case where there are no caps on your recovery and you get attorney's fees? What's the status of that case? I would think that the jury verdict in Baltimore City might have some impact on your recovery in that case.
The outcome was a jury verdict in Mr. Younger's favor, which is now on appeal.
And how much did the federal jury give him?
$700,000.
And I'm wondering does his recovery under the Tort Claims Act offset what he recovers from the correctional officers under Section 1983?
The answer is potentially, depending on some decisions on the state side.
Yeah. All right. Thank you.
Thank you.
Thank you, Your Honors.
Very well, Mr.